Next, to Infrastructure Finance and the Corporation of Hamilton.
So good morning, Lord Panic. We're very grateful to everybody involved for making themselves available at 10 o'clock. It's in order to enable one of us to meet a commitment this afternoon if this case were to run for a full day, but it strikes us as raising quite a short point.
It is a short point.
Yeah. And can I say, as we're going to be sitting for 3 hours this morning, if you were able to find a convenient point around about 11:30, then we might break for 5 or 10 minutes.
The board will have seen that for many years the Corporation of Hamilton took the view that it was in the interests of ratepayers for a car park owned by the municipality to be developed into a hotel complex. The issue on this appeal is whether the corporation had statutory power under the Municipalities Act, as amended, to give a guarantee, and it's a guarantee in respect of a bridging loan which the appellant gave to a company which was developing the hotel complex under an agreement with the respondent. And we say, my lords, my lady, that a striking feature of this case is that the legislature of Bermuda amended the 1923 Act for the purpose of ensuring the validity of the guarantee, and indeed the legislature expressly approved repeatedly the giving of this guarantee. We say on the proper interpretation of the language of the Act, the corporation did have power to give this guarantee, but at the very least from our point of view, the terms of the Act do not preclude an interpretation which accords with the understanding of the legislature that the corporation did have power to give this guarantee. We say unless, which is not the case, unless the board is compelled to do otherwise by the words of the Act, the board with respect should adopt a construction which is consistent with the intentions and the understanding of the legislature. Lords, my lady, the commercial background is set out in the agreed statement of facts. I wasn't proposing to take any time on that unless I'm asked to do so. It's set out in paragraphs 1 through to 4 of the agreed statement. Can I show the board the relevant statutory provisions, make my brief submissions on them, and then turn to the submissions on the intentions and the understanding of the legislature, seeking, as I do so, to answer the points made by the corporation in its written case. You will find the Municipalities Act in Authorities Volume 1, it's tab 3, and it's page 987. Municipalities Act 1923. There's no dispute that the Act does not expressly state the powers of the corporation. However, section 23, which the board can find on page 1013, there's no dispute that section 23 does set out the purposes for which the corporation may levy and collect annual rates on property. And the purposes for which the corporation may lawfully act must at the very least include the purposes for which it may lawfully levy rates. The corporation agrees with that, subject to not accepting, I think, the qualification at least.
Can I ask, Lord Panic, is the corporation, as it currently exists, a body created by statute?
Yes, it is.
I'm looking at section 7, but I also noticed there was a statute of 1793.
Well, indeed. That's the historical origin of it, but it is a statutory corporation.
Yeah.
Section 23(1) sets out a number of purposes for which rates may be levied. A, security guards, traffic wardens, watchmen for duty within the municipal area. B, which has been repealed, concerned the provision of fire services. It was repealed in 2007 because fire services were centralised in Bermuda. C, sanitation or health purposes, whether within or outside the municipal area. D is sewage, municipal sewerage, drainage or water. E, widening, improvement, lighting, maintenance of streets, alleys, etc. within the municipal area. Double E, construction, maintenance, upkeep, renewal of off-street parking. And then F, on which we rely, such municipal purposes being purposes of an extraordinary nature as the minister may in any particular case approve. And then G, any other purpose which is incidental to the general administration of the municipal area in accordance with this Act. And for the purposes of F, there was a finding below that ministerial approval had been given. The Court of Appeal judgment, paragraph 8, deals with that. I wasn't proposing to take time on it because it's not in dispute, but paragraph 8 of the Court of Appeal judgment. We say section 23(1)(f) does confer power on the corporation to issue a guarantee to facilitate the development of a hotel and car park on the corporation land.
Would it have conferred power to carry out the development themselves?
Was it? I'm sorry, my lord.
Would it have conferred
Yes,
power
in my submission.
for them to carry out the... So they could act as developers under F?
It could act as developer subject to section 20, subsection 2, which deals with building. If your lordship goes back to page 1011, section 22, the corporation are empowered to build, construct, erect or cause to be built, constructed or erected any building or carry out any works upon such land owned by or under the control of the court, where such works are calculated to facilitate or is conducive or incidental to discharge or any function of the corporation. So that would be a specific power to build, but that power is linked to facilitation, discharge of a function.
So which function would carrying out the development themselves
But it would again be 23(1)(f) in my submission.
So if you're wrong on 23(1)(f), your position is not improved by 22A.
No, 22A, we have to show a function of the corporation.
But if it's not a function under 23(1)(f), I understand you to accept that it's not a function at all. Or is
Well, I also have submissions in relation to the guarantee under section 20, subsection 1A, and also section 37. And my submission is that even if I'm wrong on section 23(1)(f), then we get home under section 37 for reasons I will seek to explain, and indeed under section 21A in relation to the guarantee. But in relation to building, building is specifically dealt with under section 22A.
And the function under 22A would be a function of providing hotel accommodation?
Well, no, it would be building a hotel. That would be the...
Well, that can't be a function in itself. You're allowed to build a hotel for the purposes of some functions. So the function's got to be something broader than just the construction of the hotel.
And it would be to advance the interests of Hamilton, for example, as a tourist location or matter.
But where do we find that as a function?
Well, it would be as a function 23(1)(f), municipal purposes being purposes of an extraordinary nature, as the minister may in any particular case approve. And the answer will depend upon the construction that the board gives to that phrase. Now, the background to this is set out by Mr. Justice Hellman at first instance. If we could go, please, to his judgment in the Record of Proceedings, Volume 1, behind tab B1, at page 40, paragraph 2 of his Lordship's judgment, page 40, volume 1, B1, paragraph 2, His Lordship said the purpose of the guarantee was to facilitate the development by PLV of a hotel on the site of the car park in Hamilton. The corporation, under the administration of the Mayor, who was in office at the date and during the negotiations leading up to it, and the previous administration of Mayor Gosling, viewed the development as desirable in the best interest of the municipality, as had successive governments. So that's the background. One other document which appears in volume 2 of the record, behind tab 3, at page 323, which is a letter from the Mayor at the time.
What page?
Page 323, Lord. This is a letter of June 2013 from the Mayor Outerbridge, and he sets out at 323 why the corporation was proceeding in this way. It's a letter to the corporation's lawyers. We're writing to provide a succinct yet sound rationale advocating the decisions taken by the current and former administrative councils of the corporation in support of the hotel and residences. The current hotel project proposal has been in the works for about 7 years. The corporation has embraced the need for having a first-class 5-star branded St Regis hotel within the city of Hamilton. It will provide critically needed luxury hotel accommodation to meet the strong demand by affluent business travellers to our city, equally providing first-class modern conferencing and business concierge services regularly sought after in luxury city hotels. Additionally, by incorporating residential component, this will add to the total vibrancy of the city, will enhance revenues within other city service providers, will create opportunities for enhanced corporation rate-based revenue streams. The development of a luxury hotel is consistent with the government master plan for our tourist industry. By having the project developed upon the site of the car park, the corporation receives the added benefits of having its very valuable underperforming prime real estate redeveloped for the prospect of far more significant revenue earning purposes. Upon completion of the construction project, the corporation will receive 2 levels of underground all-weather prime city parking facilities located in an area of significant demand at no additional cost. The corporation will derive a significant greater tax rate-based facility and leasehold returns on the site than currently being realised by having a single-grade level car park at this location, etc., etc. He develops that, then over the page, in the middle of the page, there's a helpful quotation from Abraham Lincoln, always a valuable authority. So that was the judgment of the corporation. The general principle applicable in relation to the powers of a statutory corporation are very familiar to the board. The leading case, of course, is Hazel and Hammersmith and Fulham, which is in Authorities Volume 2 at tab 19, which begins at page 1474, a case in which my Lord Sumption appeared for Barclays Bank, and at page 29, in Lord Templeman's speech for the appellate committee, his lordship at page 29, which is page 1502, quoted between D and E from the railway case, Attorney General and Great Eastern Railway, just under letter C. Lord Selborne said the doctrine of ultra vires ought to be reasonably and not unreasonably understood and applied, whatever may fairly be regarded as incidental to or consequential upon those things which the legislature has authorised, ought not, unless expressly prohibited, to be held by judicial construction to be ultra vires. In the same vein, Lord Blackburn said, those things which are incident to and may reasonably and properly be done under the main purpose, though they may not be literally within it, would not be prohibited. That's the very familiar principle. Now, we say, as our first submission, that 23(1)(f) does allow the corporation, with ministerial approval, to facilitate the development of a city centre hotel on land owned by the corporation, if, as was the case, the corporation took the view that such a development would benefit the people of Hamilton for the reasons that the Mayor gave in his letter. And giving a guarantee is within the scope of that purpose, or at the very least it's reasonably incidental to that purpose. We draw attention to a number of factors. First, the language of section 23(1)(f) refers to purposes of an extraordinary nature, as the minister may approve. We say the reference to purposes of an extraordinary nature shows that this subsection is intended to have a very considerable width. It is an express power to do things out of the ordinary, a power to innovate, free from concern that other statutory purposes may not cover the matter. It is a most unusual provision. We can find no equivalent provision in other local authority legislation, and therefore we can find no previous judicial authority which has addressed the scope of a provision remotely comparable in width to section 23(1)(f). No authority has been cited on either side of any comparable. That's the first point. The second point that I emphasise is that the width of the provision is confirmed by the fact that the legislature chose to confine it by the need for ministerial control. And the legislature, we say, has recognised that because it is conferring an exceptionally broad power, therefore it is necessary and appropriate to impose a constraint. And the constraint which the legislature has imposed is a political constraint. We invite the board to note that ministerial consent is required only in relation to section 23(1)(f). It's not required in relation to any of the other sub-provisions of subsection 23(1).
Can I just ask, your presentation and the letter we saw from the mayor are really focusing on the development and the potential benefits of the development to the municipality. A point that the judge makes is that the corporation were not, as he puts it, the purpose of the loan was not to fund the development, but to guarantee a bridging loan that the developer was taking out. Does that make a difference?
My submission, no, because if I'm right in the submission that the giving that section 23(1)(f) is sufficiently wide to cover the development, then I say, applying the authority of Lord Templeman and Lord Selborne and Lord Blackburn, the giving of the guarantee is reasonably incidental to that purpose, in that the corporation's view, and the reasonableness of it has not been challenged, corporation's view was that it was necessary to give the guarantee in order to ensure that the development could go ahead. No dispute about that. The next point I want to make on section 23(1)(f) is that the corporation has emphasised that the purpose must be for, quote, such municipal purposes. And the corporation argues, first of all, it's paragraph 10 of its written case, in the first bullet point, the corporation says that the word such links the purposes in section 23(1)(f) with the purposes in the preceding sub-provisions. And we say with great respect that's a bad point. Such does not refer backwards to the earlier provisions of the subsection. Such refers forward to such municipal purposes which are purposes of an extraordinary nature as the minister may approve. So we say that such, far from being a limitation, demonstrates the width of section 23(1)(f). It is whatever municipal purposes, if they're exceptional and which they're approved, will suffice. The corporation then argues, and the Bermuda courts agreed with this, that municipal is a term of limitation. And our submission is that municipal is a protean concept, the meaning of which inevitably depends on context. We say in the context of section 23(1)(f), municipal simply means that the purpose must be concerned with the interests of the locality and its people, as opposed to being for the benefit of another part of Bermuda, or indeed for private benefit. And we submit that the term municipal simply means what I say it means, concerned with the interests of the people or the locality, because the use of the term municipal in the other parts of section 23(1) suggests that it is concerned with this geographical concept. The term municipal appears, as the board have seen, in 23(1)(a), within the municipal area, 23(1)(c), whether within or outside the municipal area, E, within the municipal area. D is slightly different because it refers to any municipal sewerage, drainage or water systems, but again, in my submission, it's a geographical concept. And G, again, refers to municipal area.
But I mean, surely the critical point under F is that it's the purpose that's got to be municipal, and that doesn't look like a geographical concept at all.
The purposes has to be a municipal purpose, but that begs the question, what does municipal mean in this context?
It can't be limited to geography, though.
In my submission, what it suggests, the use of the term municipal elsewhere in this subsection suggests that what the provision is concerned with are purposes which are in the interests of the locality, of that part of Bermuda. I draw attention, although I don't suggest any significant assistance is gained from it, but I draw attention to the fact that in the definition section, section 1, which begins at page 989, one does find various definitions on page 991 of phrases which include the word municipal. In particular, at 991, about a third of the way down the page, municipal area means the municipal area for the time being the city of Hamilton or the town of St George, as the case may be. And there are other phrases that include the word municipal, but I don't suggest that great, indeed any, assistance is obtained.
If you had two water systems, one run by the municipality and one run by a private contractor,
yes, you could.
Which would 23(1)(d) apply?
23(1)(d), construction, maintenance, upkeep and renewal of any municipal sewerage, drainage or water system. Yes, I would accept that that would cover both.
Both of them?
Yes, it would cover both a system that was run by the municipality and one that was run, say, under contract by a private.
Under contract with the municipality?
Yes.
But let's suppose, it's a slightly strange concept, that it was simply run as an independent profit-making enterprise. It wouldn't be municipal.
If it was run simply in that way, I see the force of the argument that would not fall within 23(1)(d). But if that is right, I maintain the submission that for the purposes of 23(1)(f) is intended to be a much broader provision, the control of which is a political control. I say that to give 23(1)(f) the interpretation for which we contend does not make the term municipal otiose, as the corporation has contended. It ensures that the corporation can only act in circumstances that are in the interests of the locality and not for private interests or the interests of any other part of Bermuda. There's some assistance to be gained from dictionary definitions of the term municipal. Two have been relied upon. If the board, please, would go to the Authorities Volume 3, tab 36, at page 2087, Authorities 3, tab 36, 2087, your lordships and your ladyship will see in the right-hand column of page 2087, there's a definition from Black's Law Dictionary of municipal. First definition is of, relating to, or involving a city, town, or local government unit, which we say is a very broad concept. The second one is of, relating to, or involving the internal government of a state or country. We also have the Oxford English Dictionary, tab 43, beginning at page 2106, and at page 2107, near the bottom of the page, the heading B, these are definitions of municipal. Definition B, of or belonging to a municipality, especially under the administration, ownership or control of the local government governing authority, as municipal road, municipal swimming pool, municipal transport, etc. So in my submission, the term municipal is a very flexible concept, and indeed I submit that is precisely why ministerial consent is required by section 23(1)(f). Now the respondents' argument, and it's in their written case paragraph 10 at the beginning, they say municipal purposes means, quote, actions involving the provision of services to local residents. And the example that they give, because they were asked in the courts below, will give an example of what's within 23(1)(f that is not within any of the other provisions of section 23. The example they gave below, in which they give in paragraph 11 of their written case, is they say, well, the construction of a sports stadium. And they also accept, this is paragraph 17 of their written case, that the corporation has power to provide a local theatre. And indeed, we know from the statement of facts, the agreed statement of facts, paragraph 1, that the corporation does indeed own a theatre. And a theatre which people must pay to attend provides services to ratepayers only in the loosest possible sense. It requires a very broad...
It provides services for the world, that part of the world that lives in...
It provides services to ratepayers, to tourists, to many people. But the respondent's case is that a sports stadium, again, which one would pay to attend, and indeed anyone would attend, and the theatre are, what they say, are examples of what would, on their case, fall within 23(1)(f) and not within any of the other provisions. And one must give a meaning to section 23(1)(f) that does not make it redundant. Now, we agree...
Can I just I'm just thinking aloud, but pose an example. There are municipal golf courses in this country. So a local authority could decide that a golf course would be a viable amenity
Yes.
For the public, and decide to devote part of its land to the construction of a municipal golf course, yes, which it would then open to the public. On the other hand, if it were to decide, say for example, President Trump wished to develop a luxury hotel and golf course complex in their vicinity, within the municipality, and and they thought that might be a good thing for their area for one reason or another, and decided to give it financial support. That wouldn't be the provision of a public amenity in a way in which the municipal golf course is a public amenity.
Well, there may be facilities within the hotel which would be public amenities. There may be meeting rooms.
Well, let me simplify it, and we'll just have the golf course with a clubhouse.
I'm talking about the hotel, my lord. I'm talking about
Yes.
the hotel.
Well,
the hotel may have...
Well, I'm trying to be clear as to what makes it municipal. And I'm wondering if perhaps it's to do with, if the adjective municipal may have a connotation to do with the provision of public services or public amenities, which something like a municipal golf course would satisfy, but a privately operated golf club would not.
The municipal golf course would, in the normal course of events, require payment to use it. Most unlikely that a municipal golf course is going to be...
But it wouldn't require an annual membership fee of the same order.
A hotel that the municipality has promoted and assisted equally will be open to all on the payment. May have some facilities there which do not require the payment.
Some judge made a remark about the Ritz, I think.
Well, indeed, but my point is that it's very difficult to arrive at a definition which allows for the corporation to spend money on a theatre, on a sports stadium, on a golf course, indeed on tourism. What if the corporation of Hamilton decide that it is appropriate, as it undoubtedly is, to spend money on promoting tourism in Bermuda? Is that a service to the ratepayers? Indirectly, of course, they benefit from people coming to Bermuda. But it would be in my submission, it would be a very narrow interpretation of Section 23(1)(f), which prevents the corporation from spending money if it thinks that this is genuinely, properly, reasonably in the interests
It would have to be under F, wouldn't it? There's no other provision which...
Yes, indeed.
Recreational facilities generally, which I think I'm right in saying are catered for expressly in English local government legislation, would have Hamilton to come under F.
It would have to come under F, if at all.
Yeah.
If at all, unless Section 20 is sufficient. Then the corporations say, it's paragraph 17 of their written case, they say, well, this was a commercial venture for the benefit of PLV, that's the company building the hotel complex and car park. And their written case draws attention, just to show this to the board, they draw attention to the terms of the guarantee itself, which is at volume 4 at tab 16. It begins at page 840.
Amenities are dealt with expressly in E.
Right. Volume 4 of the record, tab 16, my lords, my lady, begins at page 840.
Sorry, tab 16.
Yes, my lord, and if the board please would go to page 844, in the middle of the page, this is section 12 of the guarantee at E. My friends for the corporation emphasise the words that follow in E, without limitation to the foregoing with respect to the contractual liability of the guarantor to perform its respective obligations, including payment obligations under this guarantee with respect to itself or its property. The guarantor agrees that the execution, delivery and performance by it of this guarantee constitute private and commercial acts done for private and commercial purposes. They emphasise that, to which my answer is that that, with respect, ignores the finding by Mr. Justice Hellman at paragraph 2, that the corporation took the view that the development was in the best interests of the municipality, and there was no evidence in this case that the corporation entered into the guarantee other than because it believed that the guarantee was very much in the interests of Hamilton and its ratepayers, because it was needed in order to ensure the achievement of the development. I say section 23(1)(f) does not exclude extraordinary purposes because they have a commercial element. Building a theatre or a sports stadium, or indeed a municipal golf course, will inevitably involve commercial elements. The element of commerce cannot take a matter outside the scope of section 23. So that's our case on section 23. Justice Hellman, at first instance, concluded that the competing interpretations of section 23(1) were, in his words, equally persuasive, unquote, on the language. Justice Hellman concluded it was only the statutory context of section 23 read as a whole which favoured the corporation. And in the Court of Appeal, Justice of Appeal Bell, speaking for the Court of Appeal, approved the reasoning of Justice Hellman. It's paragraphs 11 and 38 of the Court of Appeal judgment. We respectfully submit that it would be wrong in principle to seek to interpret section 23(1)(f) by reference to the other provisions of section 23(1), whether by reference to the ejusdem generis principle or any other similar principle. And that's because the whole point, we say, of section 23(1)(f) is to confer a power for purposes distinct from the other provisions of section 23. That is, purposes of an extraordinary nature. And if that's right, then it would be wrong in principle to confine section 23(1) by reference to the other provisions of section 23. At the very least, we say, section 23(1)(f) does not unambiguously exclude a power to give a guarantee in the circumstances of this case. And if there is ambiguity, then, as I shall seek to explain, we invite the board to give 23(1)(f) an interpretation which upholds the validity of the guarantee as the legislature understood and intended. So that's section 23. We next rely on section 37, which is at page 1021. And section 37 is under the heading Powers of Corporation with respect to borrowing, limit on powers of corporations to borrow money. And 37.1 at page 1021, tab 3 of the authorities, 37.1, the corporations of Hamilton and St George's respectively shall not borrow, receive or hold upon loan any sums exclusive of any sums which the legislature has authorised or shall authorise either of such corporations to borrow, and then the words or guarantee, which were added by the Amendment Act, section 16 of the Amendment Act in tab 4, to borrow or guarantee for specific purposes in the whole exceeding at one time, in the case of the Corporation of Hamilton, $30 million, or in the case of the Corporation of St George's, $1 million. The corporation accepts, of course, it's paragraph 30 of its written case, that it does have power to give a guarantee, but it says only for a purpose which is consistent with Section 23 or any other relevant provision of the Act. Now,
So are you saying that 37(1) is subject to no constraints? They can guarantee up to $30 million for any purpose whatever.
I say yes, with the authorisation of the legislature. There needs to be a specific authorisation of the legislature. And if that is given, then the answer to your Lordship's question is yes.
So, for example, they could, for purposes of profit, decide to develop a hotel in Miami, or rather guarantee the development of a hotel in Miami, consistently with this Act, provided that the legislature authorised it.
I mean, your Lordship puts to me a very extreme example, and my answer is it's most unlikely.
Well, yes, but that's never an answer.
Well, it's the answer I give. Can I explain to your Lordship why I give that answer? Because the phrase used in Section 37(1) is guarantee for specific purposes. It's not for municipal purposes. And therefore, Section 37(1) is not linked to Section 23(1)(f).
Well, surely it's a limitation. It's not a power-conferring provision. It's a provision which limits the extent to which a power that might be derived from some other part of the Act can be exercised.
The submission I make, your Lordship has the submission, that this is, again, a very broad power. It's a power that is given subject to a most unusual form of political control. By contrast with Section 23(1)(f), it's not enough to have ministerial consent. You need legislative consent, which must mean the consent of both houses of the Bermuda Parliament. That's the second submission. But I don't need to go that far, because in the alternative, I do say that it is open to the corporation to give a guarantee under Section 37, read with Section 20. Can I go back, please, with the board to Section 20, which is at page 1011. Powers of corporations with respect to real and personal property. Section 21, Section 20, subsection 1, subject to subsections 1A to 1C, and those provisions again were amendments made by the Amendment Act. Subject to subsections 1A to 1C, the corporations of Hamilton and St George's respectively are hereby empowered, A, to purchase, take, hold, mortgage, pledge, deal with, and dispose of, at their own will and pleasure, all manner of goods, chattels, and other personal property. B is in relation to land. They can purchase, take, hold, receive, and enjoy, give, grant, release, demise, assign, sell, mortgage, or otherwise dispose of and convey by deed under the seal of the corporation any land in Bermuda in fee simple or for a term of life or lives or years or in any other manner. And the amendment legislation then added 1A, 1B and 1C. And 1A, any agreement for the sale of land, which is the property of the corporation, or a lease, conveyance or other disposition of any interest in land, which is the property of the corporation, being a lease, disposition or conveyance expressed to be for a term exceeding 21 years, or for terms renewable exceeding in the aggregate 21 years, and any related agreement must be submitted in draft to the Minister for approval by the Cabinet and be approved by the legislature. And 1b, the approval of the legislature referred to in subsection 1a shall be expressed by way of resolution passed by both houses of the legislature, approving the agreement and communicated to the governor by message. So again, a form of political control is imposed by section 21a and 1b. 1c then deals with the consequences if the relevant procedure is not followed. Subsection 2 then deals with building, and the control there is the control that I've already referred to, calculated to facilitate or is conducive or incidental. There's no political control under section 22. By political, I mean approval of the legislature.
Within 20 subsection 1, the notion of dealing with personal property is quite remote, isn't it, from the issuing of a guarantee?
Well, in my submission, to deal with is a very general term that allows the corporation to guarantee a transaction, particularly when read with section 37.1. The section 37.1 recognises that the corporation does have a power of guarantee, and I'm inviting the board to give the concept of deal with an interpretation that is sufficiently broad to cover the giving of a guarantee. And indeed, as I shall show your Lordship and the board generally, that was how the legislature itself understood the matter, because when this guarantee received specific approval by the legislature, they did so pursuant to section 37 read with section 20, subsection.
Are you submitting that section 20 sub 1 is not limited by reference to the purposes or functions of the municipality?
The functions in section 23, is that your
well, and, I mean, are you saying that 20 sub 1 is, so to speak, a freestanding power which is not limited to, for instance, dealing with goods and chattels for some specific purpose related to the functions of the municipality?
It must be in the interests of the municipality. That is implicit. What I don't accept, for the purposes of this argument, is that if my submissions on section 23 1F do not find favour, that the functions for which the corporation may lawfully act under section 20 subsection 1A are limited to the functions which are set out in section 23.
You don't accept that?
I don't accept that, no. And
So,
not least because there is no suggestion in section 20 subsection 1 that those powers are so limited. There's no suggestion of that, and indeed I say that the inclusion in section 21A and 21B of what I've called political control is explicable by the breadth of the powers that are otherwise conferred.
Well, there isn't any political control, is there, in relation to dealing with all manner of goods, chattels and personal property?
Well, it's under 1A, it's land and any related agreement. So one may have an agreement which is not for the sale of land or for lease conveyance, etc., but it's related to it.
But if the municipality were to decide that it was in the interests of the municipality to raise money by operating a car hire business in Miami, that would appear not to require any political control, and your submission that it's not subject to the general limitation of the authority's purposes would appear to authorise that.
I would accept that there must be, as I've already said, I would accept there must be an implicit limitation that it is confined to what is in the interests of the general area, the
But it
geographical
might be in the
area.
interests of the general area for the corporation to make money out of running a car hire business in Miami. They would then be able to subsidize the provision of services and reduce the
Well,
rates.
obviously I don't need to go that far. I'm
Well, no, but I mean, you're making a submission, the implications of which are much wider than the purposes for which you actually require in this appeal, but that's a legitimate way of testing whether you're
Of
right.
course, I don't complain of that, my lord, but I'm seeking to give these general terms, to recognise in these general terms there must be an implicit limitation that what is done has at least a geographical link to the geographical area of Hamilton. But what I don't accept, if I'm wrong on 23(1)(f), that there is some other limitation, because none is contained therein. And I'm also, as I'm coming on to, I also submit that was how the legislature itself understood these ambiguous provisions in all the circumstances of this case.
Can I ask Lord Panic a different point, but it relates to the same argument, that there are powers held by the corporation which go beyond those that are listed in Section 23. The purpose of Section 23 is to tell us the purposes for which rates can be levied.
Yes.
And if those are not the only purposes for which the local authority can act, then I think it follows that they have to organise their financial affairs in such a way that effectively the money which is raised from the rates has to be hypothecated for the Section 23 purposes, and they have to have a separate financial accounting system for the exercise of powers which aren't based on Section 23, because they can't use any money raised from the rates for that purpose.
Yes. But it's not unusual to have separate provisions that deal with raising funds and the purposes for which the authority may spend money. For example, we have in the bundle Section 111 of the Local Government Act. If the board would go to Authorities Volume 1 and turn back to tab 2, the board will see the very familiar Section 111. 111.1 deals with the subsidiary powers of the local authority, and 111.1, without prejudice to powers exercisable apart from this section, a local authority shall have powers to do anything, whether or not involving expenditure, borrowing or lending money, or the acquisition or disposal of property or rights, which is calculated to facilitate or is conducive or incidental to the discharge of any of their functions. And 3, the local authority shall not, by virtue of this section, raise money, whether by means of rates, precepts, or borrowing or lending, except in accordance with the enactments relating to those matters respectively. So there's not necessarily a match.
No, if the statute expressly enables the local authority to spend money for purposes for which it can't levy rates, well, so be it.
It's not an unusual thing, is my submission, and therefore I say it's not altogether surprising that one finds in an act which does not expressly set out these are the purposes for which the authority may act, that one has Section 23, which deals with powers to levy rates. One finds Section 20, which in my submission gives broad powers in relation to the use that may be made of property and personal property, of real property and personal property. And there's no link between the two. There's no suggestion by the legislature that Section 20 is subject to Section 23, And one also has, as I've said, section 37, which again, neither expressly nor in my submission implicitly, is confined to section 23. Indeed, it doesn't use the concept of municipal purposes in section 37. So one has a variety of different powers. It doesn't matter for our purposes which of these powers it provides the basis for the guarantee. Our primary case is section 23(1)(f) because it's the easiest in that everyone accepts that section 23 does set out valid purposes for which the corporation should act. My submission is that if the board is not persuaded to give section 23(1)(f) a sufficiently broad interpretation to meet our purposes, then in the alternative, we rely on section 37 read with section 20. That's how I put my case. Now, the position adopted by the legislature is this, and this is relevant because if there is any ambiguity about the meaning of these various provisions, we say that the board should seek to give effect to the intentions of the legislature. Now, there's no dispute that in early 2013, the corporation was concerned as to whether it did have power to give this guarantee. And the board may have seen that the corporation was advised by counsel, it was Charles Flint QC and Gerard Clark. The corporation was advised by them that it lacked power to give the guarantee. And their opinion is in the record. I give you the board the reference. It's volume 2, tab 3. It's page 284. That was their advice. There's no dispute that because of concerns about the scope of the corporation's power, that is, did the corporation have the power to give this guarantee, the government of Bermuda brought forward amendments to the Act in 2013 which were intended to ensure that the corporation did have power to give the guarantee in this case. And without taking the board through the detail, the amendments that were actually made were those that I have indicated. The words "or guarantee" were added to section 37, and section 20 was amended to add section 21A, 1B and 1C. Those were the amendments. There were other amendments, but these are the crucial ones. Now, I submitted that there's no dispute that those amendments were made to ensure that the corporation did have power to give the guarantee in this case. And can I show the board why I say there was no dispute about that? It comes from the agreed statement of facts, which the board has. I have a further volume called Appeal Papers. I'm not sure how the board has the agreed statement of facts, but it's at page 920 of the record, maybe in a fourth, maybe separate, I don't know. Does the board have a document, statement of facts?
I put it separately.
Thank you. It's at page 920.
It's not continuously paginated in my version.
I apologise.
Paragraph?
The relevant paragraph is paragraph 9 on page 922, which tells the board it was agreed between the parties that the 2013 Amendment Act was intended to, quote, cure the ultra vires concerns. That's the agreed fact. And that language comes from the first affidavit of Mr. Benavides for the corporation. His affidavit is in the record of proceedings at volume 2, and it's tab 2, begins at page 82, and he tells the Bermuda courts at paragraph 1 who he is. He's the Chief Operating Officer and Secretary of the corporation. And he refers, if we please turn on to page 94, he refers at paragraph 45 to the amendments made by the 2013 Act. I haven't taken the board to the Amendment Act. It's in the Authorities, Volume 1, Tab 4, but I've summarised, I hope accurately, its terms, its relevant terms. He refers in paragraph 45 to, in particular, the amendment to section 37, and then over the page 95, paragraph 46, he attaches pages from Hansard, and he says that he believes the amendment was intended to cure the ultra vires issue that had been raised. So that's why the statement of facts says what it says. There's other evidence, but I don't propose to take time on it because it's an agreed statement of facts. Now, it's not merely that the purpose of the 2013 amendment legislation was to, quote, cure the ultra vires concern. It is also, in this case, that the legislature expressly authorised the corporation to give the guarantee that we're arguing about. And if we go back, please, to the agreed statement of facts, page 920, this begins at paragraph 12 of the agreed statement, which records that pursuant to section 37(1) of the Act, that's the guarantee provision, the House of Assembly passed a motion on the 29th of November 2013 authorising the respondent to issue a maximum guarantee of $18 million for developing a hotel on the car park. And in December, the Senate passed an identical motion. And the footnote reference, I'm afraid, is not accurate. What the footnote reference is referring to is the notice of motion, which was placed on the order paper. That's what happened on the 29th of November. But the approval by the House of Assembly was not until the 11th of December. Can I hand up a page which supports that? I'm very grateful. My friends have got this, I hope. Yes. This is the House of Assembly, 11th of December 2013. This document's not in the bundle. As I say, paragraph 12 is not quite right. If the board looks, please, in the left-hand column, at the bottom of the left-hand column, the board will see that the Speaker is the Honourable Michael Dunkley. He's the Minister. And he moves a resolution. He now moves that this Honourable House authorise, in accordance with section 37(1), the giving of a guarantee up to a maximum of $18 million by the Corporation of Hamilton for the purpose of developing a hotel on the site of the Parlerville car park. And the Speaker then puts the motion and concludes that the ayes have it. So that's the approval by the House of Assembly of the guarantee in principle, and a similar motion was approved by the Senate, as paragraph 12 of the Statement of Facts states, and we can see that at volume 3 of the record, if I could invite the board's attention, please. Volume 3 at tab number 7, page 635, the board will find at 635, volume 3 of the record, tab 7, page 635. This is a message to the Governor from the President of the Senate, and she records that the Senate, having had under consideration the following motion, that the Senate authorise, in accordance with section 37(1), the giving of a guarantee up to $18 million by the corporation for the purpose of developing a hotel on the site of the car park, has the honour to inform Your Excellency the Senate has approved the said motion in accordance with the provisions of section 14(4) of the Municipalities Amendment Act. Now, that provision the board has not yet seen, and perhaps I should just draw attention to the Amendment Act. It's actually the 2013, not 15, 2013. The Amendment Act, section 14(4), appears in volume 1 of the authorities, behind tab 4, it's on page 1046. And section 14 is dealing with agreements entered into by the corporation on or after the 1st of January 2012 and before the coming into operation of this section. And the relevant parts of the Amendment Act came into force on the 15th of October 2013. And section 14, any agreement entered into on or after the 1st of January 2012 before the coming into force of the operation, the sale of land, lease, conveyance, and any related agreement on or after the 1st of January before the coming into operation must be submitted by the Minister, must be submitted to the Minister by the corporation. And 4, subsection 4, the Minister shall lay the agreement before the legislature for its consideration, and the legislature shall either approve or reject. So that's the reference there. So at the end of 2013, both houses of the legislature approve the giving of a guarantee, and there was in fact a second round of approvals, this time in relation to the actual negotiated guarantee. And we see that from the certificate from the Speaker of the House of Assembly, which is in the Record of Proceedings, Volume 2, behind tab 3, at page 444.
I mean, none of this is disputed.
It's not, but can I just show Your Lordship the...
And you feel that the impact of this, the document...
Yes, well, I'm coming to that.
Recording consent is going to be greater than simply the parties' agreement that there was consent.
Well, it's not simply that there was consent, it's that the legislature addressed this specific guarantee and gave its approval, and I'm coming on, of course, to...
do it by legislation, and therefore we're left with the legislation that they did pass, which is the amended 23 Act.
Well, what I'm going to submit to Your Lordship is if the legislation that was enacted is ambiguous, if the construction for which we have contended is a tenable one, whether under section 23(1)(f) or any of the other relevant provisions, the board should seek to give the legislation a construction that is consistent with the understanding and the intentions of the legislature. Otherwise, the legislature, its intentions have been frustrated, and it has acted for naught. And it would, in my submission, be a remarkable thing to say that although the legislature understands that the corporation does have a power to give this guarantee and has blessed this particular guarantee, the courts, including the board, are to prevent the corporation from doing so. But I'll come to that, if I may. Can I just show...
Before we do, can I just mention, while it's in my mind,
Yes.
that the copy we have of the 1923 Act omits the preamble.
Ah.
It may not help us, but you never know. We would need to look at it anyway.
Yes, well, thank you. I hadn't noted that. I'm grateful to your Lordship. We'll try and find it. It may not be that we can rectify that before the end of the proceedings, but we can certainly send it in to the board and liaise in relation to that. Can I then show the board the second round of approvals, this time in relation to the actual negotiated guarantee? And there are two documents. The first is at page 444. It's record volume 2 behind tab 3, page 444. It's a certificate from the Speaker of the House of Assembly to the Governor, the House of Assembly having had under consideration the proposed guarantee by the corporation in respect of the loan by MIF, the appellant, to Parleville, the borrower, set out in the draft of the guarantee agreement, has the honour to inform Your Excellency that the House has approved the said agreement in accordance with the provisions of subsections 1A and 1B of section 20 and section 37 of the Municipalities Act. So there is a specific reference to the amended version of section 20 of the legislation, and likewise the Senate, if the board please would turn on to page 449. This is from the President of the Senate. She tells the Governor, the Senate, having had under consideration the proposed guarantee, etc., etc., and it's in the same terms as the House of Assembly one. And I emphasise this is in relation to the specific guarantee that we are concerned about, not in principle, but this specific guarantee. Now, I say that the legislature, therefore, must have understood, it must have intended, it must have believed that the corporation did have power to issue the guarantee in the circumstances of this case. The legislature could not sensibly have authorised the guarantee, having amended the legislation, without believing and intending that the corporation had a lawful power to give the guarantee. And
Right, but the issue before us is whether that belief was correct.
It is, but the case for the corporation has to be that it's not merely the corporation that misunderstood the scope of its statutory powers. Their case has to be that the legislature, having amended the 2013 Act, also misunderstood the scope, the lawful scope, of the powers which it had conferred originally and had specifically amended in order to cure the defect.
I mean, this goes much further than pepper and heart kind of material. It's, you're making a submission that because after the Act is passed, the legislature assumes that it authorised something, that should be a factor encouraging a court to agree. And that, I'm not sure what constitutional principle supports that.
I'll show you, Your Lordship and Ladyship, two cases in relation to this, but I do say that if and to the extent that the legislation is ambiguous, yes, courts should seek to give legislation a meaning which accords with the intentions and understanding of the legislature. And there are two authorities that we rely upon, and the first certainly would be very familiar to the board. It's the observations of Lord Bingham for the Appellate Committee in Quinta Vale, Authorities Volume 3, tab 25, case about human fertilisation. The relevant passage appears, this is in the electronic numbering, it's page 1777. It's volume 3 of the authorities, tab 25. The relevant passage is in paragraph 8 page 695 of the law report, page 1785 of the electronic numbering, paragraph 8, Lord Bingham speaking for the appellate committee, the basic task of a court is to ascertain and give effect to the true meaning of what Parliament has said in the enactment to be construed. But that is not to say that attention should be confined and a literal interpretation given to the particular provisions which give rise to difficulty. Such an approach not only encourages immense prolixity in drafting, since the draftsman will feel obliged to provide expressly for every contingency which may possibly arise, it may also, under the banner of loyalty to the will of Parliament, lead to the frustration of that will, because undue concentration on minutiae of the enactment may lead the court to neglect the purpose which Parliament intended to achieve when it enacted the statute. Every statute, other than a pure consolidating statute, is, after all, enacted to make some change or address some problem, or remove some blemish, or effect some improvement in national life. The court's task within the permissible bounds of interpretation, and that's why I've emphasised to the extent that the language of the Act is ambiguous, because I'm not inviting the court to rewrite legislation.
That's not the only permissible bound of interpretation. You're, I think, inviting us to have regard to what might appear to have been the assumption of the legislature when not acting in a legislative capacity many years after the Principal Act was passed and a little bit of time after the Amending Act was passed.
Well, I'll come to the question of how a later amendment can affect the meaning of an earlier provision. That's the second authority. But it's within the permissible bounds of interpretation is to give effect to Parliament's purpose. Well, Parliament's purpose in this case, and it's a most unusual case, a case where the legislature itself has expressly given approval to the implementation of the statutory powers. And I say there's no constitutional objection, far from it, to the court having regard, if the statutory provisions are otherwise ambiguous, to the court having regard to how the legislature itself understood. I say it would be, with the greatest of respect, it would be to apply blinkers for a court to say that we're simply going to ignore the fact that the legislature has understood the powers that it has conferred as authorising the corporation to give this guarantee. It is to frustrate all the expectations which are reasonably enjoyed by those who have to take note of what the legislature has done. The legislature has not merely addressed a problem here. It's not merely said we are concerned as to whether the corporation has a power to give this guarantee, so we will enact legislation, amendments, as the court has, as the committee has seen, as the board has seen, to confer such power. But we're actually going to address the specific guarantee, the exercise of that power, and we're going to approve it. And Lord Bingham says the controversial provision should be read in the context of the statute as a whole, and the statute as a whole should be read in the historical context of the situation which led to its enactment. And I do submit there's nothing constitutionally objectionable in assessing history, in having regard not just to what led up to the legislation being enacted, but also in having regard to the way in which the legislature itself contemporaneously, this is not years later, but contemporaneously, what it understood the legislation to enact. Now, I emphasise, I'm not submitting, of course, that the board should displace unambiguous language because of what the legislature intended or understood. That is not the submission. The submission is confined to a situation where the legislation as enacted is otherwise, in the view of the board, ambiguous. And if I've failed to persuade the board that the legislation is at the very least ambiguous in the relevant respects, then none of this will help me. I recognise that. My submission is founded on the ambiguity of the language. And if I'm right on that, at the very least if I'm right on that, then I do say to ignore the context, the history, is supported by no constitutional principle, and it would mean the board, as the senior appellate court of Bermuda, with great respect, frustrating the clear and obvious intentions and understanding of the legislature.
Can I just understand, are you using this submission, I understand you're using it in relation to the effect on sections 20 and 37 of the amendments. Are you also using it in relation to the meaning of section 23, which wasn't amended at that time and was passed
That's more difficult.
back in whenever it was, I mean many, many years previously?
That's much more difficult because the amendments did not address section 23, and your lordship has seen that the approvals of this specific guarantee did not either address section 23. The approvals were by reference to section 20 read with section 37. However, I do have a submission by reference to an earlier board decision that it is permissible to have regard to later statutory amendments in order to interpret a statutory provision enacted sometime earlier. And if the board is going to adopt the approach that the purposes for which the corporation may validly act are confined, essentially, to the functions set out in section 23, then I do submit that in interpreting section 23, it is permissible for the board to have regard to the later understanding and intentions of the legislature, even though it has not in fact amended section 23. But can I show the board the case? It's the Hang Seng case, Authorities Volume 2, and it's at tab number 18. And it's a decision of the board in 1990. It's a tax case. And the advice of the board was given by Lord Bridge. I noticed the time, my lord. Your lordship,
Yes,
Deputy President.
Well, if this is a convenient moment.
Well, it would be. I haven't got much more,
No,
my
that's-
lord, but this may be a convenient
Yes,
moment
certainly.
if the board wants to rise.
Yes, we'll rise for 10 minutes. We'll try to make a prompt start in 10 minutes' time. Yes.
Lords and my lady, the Hang Seng case, volume 2 of the authorities, tab 18, it's page 1455 of the electronic bundle. Lord Bridge giving the advice of the board, which begins page 316 of the law report, page 1465 of the electronic bundle, and the board was concerned, as your lordship shall see from letter H on page 316, with section 14 of the Hong Kong Inland Revenue Ordinance, which included the phrase in the last line of that page, assessable profits arising in or derived from Hong Kong, and over the page, 317, letter C, in 1978, an amendment of the ordinance changed the law. Section 15.1 opens with the words, "For the purposes of the ordinance, the sums described in the following paragraph shall be deemed to be receipts arising in or derived from Hong Kong." And then there's a bit more detail, which I don't think matters for present purposes. The point is at page 323 of the law report, 1472 of the bundle, at letter G, it was put to council that section 15.1.1, which deems the interest on offshore loans made by a financial institution which is not otherwise chargeable to tax under this part to be nevertheless a receipt arising in or derived from Hong Kong, demonstrated that without the deeming provision, section 14 could not be construed in such a way as to subject the interest to profits tax, and thus refuted the contention the bank's profit now in question was so subject. To this, council responded that the legislature cannot, by an amendment to existing legislation, which proceeds upon a mistaken belief as to the effect of a provision in the original enactment, alter the meaning of that provision. This is no doubt perfectly correct if the meaning of the original provision is clear and unambiguous, but it is otherwise if there is any ambiguity in the original provision. The principle is clearly stated by Lord Sterndale, Master of the Rolls, in the Cape Brandy Syndicate case, where he said, "I think it is clearly established in Clarkson that subsequent legislation on the same subject may be looked to in order to see what is the proper construction to be put upon an earlier act where that earlier act is ambiguous. I quite agree that subsequent legislation, if it proceed upon an erroneous construction of previous legislation, cannot alter that previous legislation. But if there be any ambiguity in the earlier legislation, then the subsequent legislation may fix the proper interpretation which is to be put upon the earlier." And Lord Bridge concludes, "This statement has subsequently been referred to with approval on a number of occasions by the appellate committee." So that's what we rely upon to support the contention that if and to the extent that section 23(1)(f) is otherwise ambiguous, and if the board is unpersuaded by our other submissions on section 37 and section 20, the fact that the legislature has proceeded on the basis that the corporation does have power to give this guarantee means that the board is entitled to construe the ambiguous 23(1)(f) in a way which accords with the understanding of the legislature, even if the legislature has misunderstood the earlier legislation. That's the principle for which we contend.
Are you making one jump further than Lord Bridge? He's talking about looking at the interpretation of the amendment to see if it helps, or the meaning of the amendment, to see if it helps resolve an ambiguity in the legislation which it amends. But I think you're talking about having recourse to the underlying subjective assumption of the legislator when making the amendment, rather than the terms of the amendment itself, for the purpose of then going back to look at section 23. Because I understand it, you rely on this if you don't get anywhere under your section 20 and 37 submissions.
Well, the way that the principle is put in the passage from the Cape Brandy Syndicate case, which Lord Bridge approves at page 324b, is whether the subsequent legislation is on the same subject. So it's not a principle confined in my submission to the question as to whether they've amended, whether the legislature has amended a particular provision. It's legislation, subsequent legislation on the same subject. And I do submit that the same principle applies, even though the subsequent legislation has not addressed Section 23. And the same principle applies in my submission, because the subject matter with which the legislature was concerned, and with which the board is concerned, is whether the corporation had lawful power to give this guarantee. And the legislature plainly proceeded on the basis that, yes, it did. And if my other submissions do not find favour, then I do say that the legislature's understanding, when it amended the legislation, is a factor that the board, with respect, should take into account and act upon in seeking to interpret the proper meaning of the provisions of this legislation. So we emphasise that this is a most unusual case. It's a case where the corporation gave the guarantee to advance the development, which was very much in the interests of the locality of Hamilton, as set out in the Mayor's letter, which I showed to the board earlier this morning, Volume 2, Tab 3, 323. That was the intentions of the corporation, that was their understanding. There's no suggestion that they were acting otherwise than reasonably in forming the view that to give a guarantee of this nature was to advance the development, which was very much in the interests of the locality of Hamilton. And secondly, we have the exceptional circumstance here that the legislature had power to give, the legislature proceeded on the basis that it wanted to confer power on the corporation to give this guarantee. And the legislature expressly approved the giving of this guarantee by the resolutions that were enacted. We therefore submit that the 1923 Act, as amended, containing as it does no express provisions listing the purposes for which the corporation should be interpreted in order to validate the guarantee in the circumstances that I have identified. And whatever may otherwise be the limits on the powers of the corporation, although if necessary we would submit that they have broadest possible powers, the corporation does have a power, whether under Section 23(1)(f) or under Section 37, read with Section 21A, to give a guarantee which in its view will advance the interests of the development, which will be very much to the advantage of the locality of Hamilton and its ratepayers. Those are the submissions I wanted to make on behalf of the appellant in this case.
Thank you very much, Lord Hennick. Mr. Adamson, do you follow? Mr. Beloff, the board would be grateful for your assistance in relation to Section 23. We don't feel we need to trouble you in relation to Section 37, read with Section 20.
Or read separately.
Or read separately.
Or read separately. May I just start by reminding the board of this. The There were three routes identified by Lord Panic, and your lordships appear to have determined, and my lady, that two of the routes are cul-de-sac, and we say the same is true of the first route. And it's not without interest that not only Mr. Flint of Queen's Counsel and Mr. Gerard Clark, but the record shows there were a number of persons in Bermuda, all lawyers, who took the view that Section 23(1)(f was an inadequate basis for the giving of the guarantee. I just list them. Mr. Delroy Duncan, who was a lawyer instructed by the Corporation of Hamilton, Terra Law, who were a local law firm, who eventually and grudgingly, but only after the amendments which your lordships and my lady have found are ineffective, gave a very general opinion that the guarantee would be validated. Mr. Flint and Mr. Clark, the Ministry of Home Affairs, and finally the Attorney General's Chambers. Now, of course, the board are not interested in the number of persons who doubted the adequacy of Section 23(1)(f, but rather the quality of the reasons that they put forward to express those doubts. In other words, it's the song, not the singer. So in mentioning those persons, I merely perhaps say that as a matter of courtesy, I acknowledge their contribution to the arguments that are ventilated on behalf of the corporation. So coming then straight to the argument in relation to Section 23, can I say by way of general introduction that, of course, we rely upon the opinion that Mr. Flint and Mr. Clark made as the most elaborate explanation as to why Section 23(1)(f is insufficient. My learned friend has given the board the references to that opinion. And of course, we rely also upon the judgments below, all of which were in our favour on this point, as indeed on the point in relation to Section 37. Section 20 was not even canvassed until my learned friend's written case. So the board have Section 23(1)(f, and we accept there is a certain measure of common ground here. It doesn't itself, the section, purport to describe the powers of the corporation. It describes the purposes for which the corporation can levy and collect annual rates. And we accept, as has been contended, that the powers of the corporation may necessarily be inferred, at least from those purposes for which rates may be levied. And we would also accept that there may be other purposes for which various discretionary powers of the corporation be carried out, those that are referred to in Section 37, the provision in relation to ordinances. But for purposes of Section 23(1)(f, which is what I'm asked to address, may I deconstruct it in this way? It requires the actions of the corporation in order to be valid, to be firstly such, secondly, municipal purposes, thirdly, of an extraordinary nature, and fourthly, as approved by the minister in any particular case. And as to the first of those two elements, our short point, which I shall develop briefly in a moment, is that the provision of a guarantee by the corporation to the appellants in respect of a loan made by the corporation to the local company PLV, the purpose of which was to put PLV in a position to meet the anticipated costs of borrowing the monies necessary to fund a property development, the construction of a luxury hotel, is simply not a municipal purpose at all. The corporation submits that such actions taken for municipal purposes means actions involving the provision of services or amenities to local residents. We submitted in our written case, that's at paragraph 10 at page 951 of the electronic bundle, that a possible interpretation of the word such links the purposes of which section 23(1)(f) is concerned with those set out in previous subsections. And we maintain that to the extent that there is any ambiguity, because for reasons I shall develop very shortly, if there is any ambiguity, given the nature of the rate-raising provision, it ought to be construed against those who contend for a particular extent of the powers. But I stress it's entirely unnecessary. I can digest my learned friend's criticism that the word such looks forward rather than backwards in the context of that section, and I come then to the more, what we say is formidable argument, and an argument that we say has not been sufficiently in any way rebutted by my learned friend, that the ordinary and natural meaning of the adjective municipal is that it relates to the function of the local or corporate government of a city, town, or district. Both parties have put forward from various works of authority and definition the definitions that they each severally contend for, and you will have seen in our written submission at page 951 the kind of meaning for which we contend, emphasizing the notion of the function. And we cite from Encyclopedia Britannica, which deals with the concept of a municipality, and as basically the response of the state government to the need for certain public services, that is to say waste disposal, police and fire protection, water supply, health services, in addition to that which is available from the county or other local governments, or one might add state governments as well.
Mr. Beloff, as I understand it, you're not distinguishing between services such as the provision of water that are made available to all ratepayers, qua ratepayers, and services such as the provision of a theatre, which are made available for such people as care to pay for a ticket. So what is the distinction between, for instance, subsidizing a theatre or managing a theatre and running a development? I mean, I can see that providing a guarantee for a development may be a stage further down the line, but let's look at the question whether you can, under F, develop a site as a hotel. What's the difference conceptually between that and providing a theatre?
Well, the focus is certainly in relation to a hotel of the character that is described, and indeed was referred to as such in the letter from the mayor, which my learned friend took the board to, is that in relation to a theatre within a particular municipality, one would imagine that the bulk of those who enjoyed its benefits, whether for payment or otherwise, but I'm assuming pursuant to my
let's suppose it was an opera house, and people therefore came from miles away from Hamilton to see something which presumably is not available on a very widespread basis in Bermuda, I don't know. Would that make a difference? Well, would it make a difference if the council had decided we must have an opera house so that we can attract, freeloaded tourists? Would that make the position different from if they'd said the population of Hamilton are seriously starved of opera and would like to go to this?
Well, I mean, like many definitional questions, I mean, the boundary is not necessarily a clear one. There is some advantage to be gained if the board would be good enough to go back to the section itself, the Act itself, and look at the section that deals with ordinances at page 1022. you will see at section 38, at 1022, some of the purposes which one would accept would be purposes certainly within the functions of the Corporation of Hamilton, include those which require to be authorised by ordinances. And if you cast your eye down from 2 through to subsection I, one can see the control and supervision of theatres, dance halls, concerts, public exhibitions and entertainments and performances.
This is about what we would call bylaws, isn't it?
Yes, that's right. Yes, indeed. And of the erection of any building intended to be used, therefore, it appears that those who drafted this legislation viewed the provision of that kind of facility, including theatres, to be something that would be provided for private purposes or by private persons, and the role of the corporation would be a regulatory role.
But this has nothing to do with the provision of these facilities by the corporation.
No.
If there are half a dozen commercial theatres in Hamilton, it can have bylaws which would regulate, ingress and egress, fire precautions, and all the rest.
No, I accept that, my lord. But what I'm suggesting is that implies that the provision of facilities of that kind is not usually to be described as a municipal purpose within Section 23(1)(f). It may be so of an extraordinary nature. That's one of the examples that was given by the Court of Appeal, the building, for example, of a sports stadium. But in our respectful submission, it takes one away from the ordinary and natural meaning of that particular word, which does focus on what one might call basic necessities rather than luxuries, if I can put it the way, to use your lordship's example of opera. And that's the way in which it is conventionally used, as we respectfully submit. The only case which either party has been able to provide in which the word municipal has ever been discussed is the case of Arnott. And I show it, if I may, to the board with a measure of reservation, because here the outcome of the case was dictated by a preamble which itself described what was considered to be municipal. But nonetheless, in our submission, it's not entirely unhelpful, since it does, in fact, illustrate what we say is the conventional way in which that word is used. You have it at 1116 in the electronic bundle. It's Joint Authorities Bundle 1, tab 9. And here, what was the issue was whether or not the certain sums could be customs alleged to be due on certain goods which were brought into the burgh of South Queensbury by the defendants by land carriage were in fact something that could be collected on the basis that the collection would be within the boundaries of the Royal Burgh for all municipal purposes, and one sees that towards the foot of the judgment, and it was decided that the levying of dues or customs simply was not a municipal purpose at all, but was a right of property which was impossible to hold, was conferred upon the magistrates by the statute in question. And then, this is the reservation that I made, even if this was less clear than the sheriff's substitute thinks it to be, the words municipal purposes must be construed consistently with the context and with the preamble of the Act, which shows the object of the legislature was merely to make more effectual provision for regulating the police of towns and populous places in Scotland, also for lighting, cleansing, paving, draining, supplying water to, and otherwise improving the same. So those are what one says with respect are illustrations of the conventional meaning of municipal purposes. And we say, if there were any doubt about this matter, that we are entitled to rely in construing the relevant subsection, which is an issue before the board, on such principles as eustem generis, or more broadly noscitur ausocies, that's to say the linguistic context. If one looks at the other examples in the section 23, they all carry the same kind of flavour, as we say is consistent with the ordinary meaning of the word municipal. The corporation is a body established by statute, as we were reminded by the question of my lord in the chair, whose officers are democratically elected to run the municipal affairs of the city of Hamilton, and it is an instrument of local government exercising powers that are devolved on it by central government pursuant to the Municipalities Act of 1923. And we respectfully submit that the kind of services that one expects a corporation of that kind to provide are the kind of services that are illustrated by the preceding sections, subsections of section 23, and this is no way deformed by the fact that the purposes have to be extraordinary in order to require the validation or approval by the minister. No quarrel appears to have been made by my learned friend with the decision of the Court of Appeal validating that of Mr. Justice Hellman. And if I may just quote, it's at paragraph 38 to 39 of his leading judgment in the Court of Appeal. It's at page 17 of 1A1, and it's set out, in fact, in our written case. The purposes must be of an extraordinary nature, which means out of the ordinary, and therefore requiring ministerial approval before rates ex hypothesi greater than usual can be levied in respect of the actions taken. That's to say, well, by example, e.g., large-scale, one-off projects such as the construction of a sports stadium. And we accept that in addition to that kind of example, there may be within the scope of a year for which rates are raised, additional funding needed. For example, recently Bermuda staged the America's Cup, the yachting competition, the premier yachting competition, and that required, of course, additional security, traffic wardens, etc., to cater for the influx. And we say section 23(1)(f) would enable the corporation to apply to the minister to authorise an extraordinary rate for that purpose as well. But the fact of the matter is that ministerial approval is a necessary but not a sufficient condition of the ability of the corporation to levy rates by reference to section 23(1)(f), because, with respect to my learned friend's argument, the fact of the matter is that although the purposes have to be of an extraordinary nature, they still have to be municipal purposes. And the fact that a reference is made to purposes of an extraordinary nature simply does not change and certainly does not alter the meaning to be attributed to the municipal purposes. My learned friend and I may debate, it may be simply a linguistic debate or debate about perspective. My learned friend says section 23(1)(f) shows the width of the ministerial power. We would respectfully respond that given that approval can only be given in respect of purposes of an extraordinary nature, that shows that in fact a limited power, but that matters not. Important for the purposes of the construction issue, the fact of the matter is that the purposes of an extraordinary nature have still to be municipal, and that the approval that is given by the minister cannot extend the meaning of municipal beyond that which it would otherwise bear. Now, my learned friend says, well, what meaning does it bear? We've already articulated what we say is the meaning. My learned friend has two arguments as we understand them. He retains the argument that municipal simply means a purpose relating to the municipality in the sense of within the geographical area that is administered by the corporation. And we, with respect, dispute that proposition. Firstly, rates could only be levied by the corporation for actions which relate to its municipal area. There's another municipal area within Bermuda, St. George's, and obviously the corporation could not levy rates on the residents of St. George's or in relation to actions taken within the St. George's area, or for that matter, vice versa. Secondly, in fact, as my learned friend helpfully reminded the board, section 23(1) itself refers to the concept of municipal area at several junctures, that's to say at subparagraphs A, C, E, and G. And to say that the proposed meaning of municipal purposes, the meaning proposed, that it is a geographical concept, in our respectful submission, would make the epithet municipal as so construed in section 23(1)(f) as OTOs. And indeed, the third submission we make is this: if it were simply a matter of actions to be taken within the geographical boundaries of the Corporation of Hamilton, then subject, of course, to ministerial approval, it would entitle the corporation to propose the building of a rocket launch, a nuclear site, a house of ill repute, or indeed anything, as long only as it was within the city boundaries. And in our respectful submission, that cannot be right when one considers that. My learned friend didn't say anything about section 23(1)(g), the ancillary section at the end. We say that it is freestanding. It's concerned with ancillary purposes incidental to general administration, not primary purposes of an extraordinary nature, and therefore our construction can tolerate the coexistence of those two subsections with equanimity. The second major point that my learned friend made is this. He says, well, any purpose thought by the minister, or indeed thought initially by the corporation, to be in the best interests of the residents of the city of Hamilton, as opposed to some other part of Bermuda for purely private benefit, that is itself a municipal purpose. We respond to that. Firstly, again, we remind the board that the adjective municipal is one which must be read as part of a composite phrase of adjective and noun. And as my Lord Sumption said at an early stage during my learned friend's submissions, and we respectfully adopt this, what one is looking to is what is a purpose that is municipal. It limits the purposes in the subsection to those which have that particular character. Now, my learned friend read to the board the classic case of Hazel, but there was a passage that he did not read, and we respectfully do to it. This is at Authorities Bundle, tab 19. The provision that my learned friend read was at page 29 of the speech of Lord Templeman 1502 at the electronic numbering. The passage he did not read was the one at page 31, which is at 1504. And he said that against letter E, the authorities also show that a power is not incidental merely because it is convenient or desirable or profitable. And he then goes on to deal with swaps transactions with their profit-making object, alas, not always, if at all, achieved, in order to increase the available sources of the local authorities, and then he goes on to excoriate some of the more exotic activities of local authorities in that particular area. But in that particular era as well. But the point is that there is a distinction between something that is convenient or desirable or profitable, all of which may be attached to the building of a luxury hotel, and something that is municipal in the sense of being the kind of functions that a local authority is entitled to carry out or discharge. And the mere fact that the corporation thought, as we assumed that they did, that the project was in the interests of the corporation, of indeed PLV, the developer, and the Bermudan public at large, which is referred to in Mr. Benevides' affidavit at paragraph 21, just the reference, it's volume 2, A3 at page 87 to 88, quoting a council resolution to that effect of the 28th of March of 2013. That's, of course, a necessary, but it is not a sufficient criterion. It doesn't ipso facto make it municipal. And there is actually an illustration now within the statutory sphere that when the Bermudan legislature wishes to use the minister's belief that something is in, quote, the best interests of a particular constituency, it deploys very clear phraseology to that effect. The amendments that were introduced by the Act of 2018 are set out in the bundle. If you go to the Act itself, that's in Authorities Bundle 1, Tab 3, Tab 6, 1075. Where have we got the correct reference? Can I just check with my learned junior? I've given you the correct reference. I can find it in volume 1, tab 6. Yes, it's set out. That's the bill. Yes. But the Act, in fact, was in the I don't know whether the Act actually has it been put in as far as you know. Well, the Act, in fact, reflected the terminology of the bill that's being handed in now.
Thank you.
Thank you.
Yes. Yes, it's probably more easy to go back in the same volume to tab 3 at page 997, where you actually have the Act as it was amended. And you see that the minister may give written directions to a corporation, whether of a general or specific character, if he considers it to be in the public interest for him to do so, and the corporation shall carry out any such directions. And he goes on to...
But I don't think the version of the 1923 Act that we have incorporates the amendments affected in 2018.
No.
I've just looked at the first of them, which
No,
was the amendment
I
to
think
section
my
7.
lord is right.
Yeah.
I think my lord is right.
But we can work from one to the other, just about.
Sorry?
Well, this was amended in 2015.
That was amended in 2015. There is a more specific provisions in 2018.
Yep.
And it's set out, yes, I'm reminded, it's actually set out in our written submission. Can I just ensure that before the conclusion of the hearing, before your board's deliberation, you actually have the relevant provisions that you ought to have to support this particular submission? But may I just, for present purposes, read out the amendments that were made by the Municipalities Amendment Act of 2018 to make good my point. Section AA1 empowers the Minister, I quote, to give written directions to a corporation, whether of a general or of a specific character, if he considers it to be in the best interest of Bermuda for him to do so. Section 7B6 permits the Minister to assume the stewardship of a corporation's infrastructure, function or service if he believes it's in the best interest of Bermuda for the government to do so. Section 7B6A, little b, permits the Minister, if he believes it is in the best interest of Bermuda for the government to temporarily assume control of the corporation's financial government, to assume such control. Or lastly, Section 7B6A, little b, permits the government minister also, if he believes it's in the best interest of Bermuda for the government to temporarily assume control of the corporation and its governance. You're not, of course, concerned in any way with the decision of the legislature to increase the grip, if I may put it that way, of central government over the activities of the Corporation of Hamilton or indeed of St. George. The point I make is a shorter and simpler one, which is that to equate municipal purposes with those purposes that are to be thought to be in the best interests of the ratepayers or residents of Bermuda is, in our respectful submission, not only warranted by the ordinary meaning to be attributed to the concept of a municipal purpose, it's at odds with what was said by Lord Templeman with the consensus of other members of the appellate committee in Hazel, Hammersmith and Fulham, and it's further undermined by the fact that the concept of something being in the best interests of the particular municipality is specifically described in different legislation, which suggests that in the view of the Bermudan legislature, the concepts were in fact different ones. And the final point I make under this heading, no, not the final point, the penultimate point I make is this. To the extent that there is any ambiguity at all in relation to what is meant by municipal purposes in subsection 1F of section 23, the board should err in favour of a restrictive interpretation, because this is a money-raising provision, section 23. It's concerned with rates, and we have cited in our written case at paragraph 16. It's page 154, amongst others, well-known principles set out in the books, Benyon and in particular Halsbury, where it is said the normal canons of statutory construction apply to taxing statutes, but in addition there are certain other considerations which may be regarded as special in the construction of such acts. Thus, it is a general principle of fiscal legislation that to be liable to tax, the subject must fall clearly within the words of the charge imposing the tax, otherwise he goes free. It's for the Crown to establish the charge prima facie extends to the subject matter sought to be charged. We say the same applies to rate-raising powers, and that in order to ensure that that principle is respected, if there is any ambiguity as to whether or not something does or does not fall within the concept of municipal purposes for the purposes of 23(1)(f, it ought to be construed in a way that limits the exposure of the ratepayers. Finally, and I think this, this is we say that giving assistance to a third-party property developer for the development of a hotel in the city is not a provision of a service to the residents of the Corporation of Hamilton. Certainly might have been a hospital, a care home, or perhaps more doubtfully a theatre. It is a commercial venture, primarily for the benefit of PLV. My learned friend very kindly did read to the board the relevant extract from the guarantee on which we ourselves rely.
That's basically directed at a completely different purpose.
It is directed, of course it is. It's in order to prevent the corporation in proceedings in New York from relying upon some kind of defensive immunity. But the point that we make with great respect is this was something, as the record shows, that MIF insisted upon and the corporation agreed to, and we say they can't effectively blow hot and cold about this. This is how they have described it. If they describe it so for one purpose, it must be so for another. My learned friend didn't take that point. He took a different point. He said, no, that submission cannot stand with the finding by Mr. Justice Holman, which he rightly says was not in any sense challenged, that there was the genuine belief in the corporation that the project was in the best interests of the residents and ratepayers of Hamilton. But we say with great respect that again fails to acknowledge that there is a distinction between something that is thought to be in the best interest of the residents of Hamilton or something that may raise money which can then be used for purposes that are properly the municipal purposes or purposes for the discharge of the corporation's functions. The mere fact that it is actually done for private and commercial purposes doesn't mean that there may not be an indirect benefit, and perceived to be an indirect benefit to the citizens of Hamilton. What we say is that that simply isn't sufficient to bring the guarantee and its provision under the umbrella of municipal purposes. And you have seen that it was encouraged, the letter that was read, because of the strong demand of affluent business travellers to the city. They are not, with great respect, the constituency for which a corporation is expected to provide services or amenities. Of course, there will be an indirect benefit in the sense that monies will accrue that can be used for other purposes that are truly the discharge of the corporation's function or are truly municipal purposes, but it isn't simply sufficient to say because there are those indirect benefits, that makes it ipso facto a municipal purpose. In other words, we put it very shortly, we would submit that a municipal purpose, if pursued, will always be to the benefit of the corporation and its residents, but the reverse is not necessarily true. The fact that
the municipality have power to set up a tourist office to encourage tourists to visit Hamilton?
Well, I don't want to avoid the question. I mean, there are matters, as it were, on the boundary there between the two. Whether that would be...
This isn't on the boundary. This is completely on what you submit is the wrong side of the boundary.
Yes, but the question is whether that be something of an extraordinary nature. It doesn't come within any of the others of an extraordinary nature. It's not of itself unusual. It's not of itself something that would impose additional demands upon ratepayers not ordinarily envisaged. My Lord
to employ people in it.
Yes, my Lord pointed out in the course.
I wonder if another way of looking at it, Mr. Belloc, might be that if you have, for example, operators of hotels, B&Bs or whatever in Hamilton, then rather than having to undertake their own promotional and publicising and so forth, the local authority, if it does it for the corporation as a whole, is providing a service to those of its residents or businesses who participate in that sector of the economy.
Well, obviously the corporation may provide money to third parties for the purposes of providing services that it might otherwise itself wish to provide in a more efficient way, but that doesn't necessarily provide the answer to, as it were, anything that they choose to do, simply because it's more generally in the interests of the residents or ratepayers. I mean, don't forget, Bermuda is a relative, as your lordship and my lady all well know, very small place. This is focusing on the municipal purposes of the Corporation of Hamilton. The fact that it is for the general benefit, indirectly, it may be, of the citizens of Bermuda is neither in our respective vision here nor there. My Lord Sumption at an early stage pointed out, as is quite clear, that what the Bermudan legislation lacks is a provision equivalent to Section 111 of the Local Government Act of 1972, the restrictions on which, of course, were recognised in the Hazel case. Still less does it reflect the Localism Act of 2011, which, for better or for worse, for most purposes, equated the powers of local authorities with those of a private corporation or individual. We simply say that one can't, because one can envisage other provisions which might have justified using corporation monies or exposing corporation funds for purposes thought to be beneficial, that one can actually necessarily shoehorn that into a provision of a limited and specific kind, such as one finds in Section 23(1)(f). It may very well be that the legislature of Bermuda, when they reflect on the outcome of this case, whatever it may be, will consider that it's appropriate to grant, as it were, wider powers to local authorities, though the Municipal Amendment Act of 2018 tends to suggest that the political imperative is to an entirely contrary effect. But we say, with great respect, when one talks about, if one asked someone, well, is something that is designed to satisfy the, quote, strong demand of affluent business travellers to the city, something that one would ordinarily say was the provision of a service within the concept of municipal purposes, we respectfully say no. It's obviously on the other side of whatever boundary may be proper to be drawn. Another point that was made by, again, occasional debate with members of the board was the question of property development by itself. Was that something that the council itself could indulge in? And we say with great respect that it can't. Again, can one look to see what was said in relation to even the amendment that was made to Section 20? And again, if you would be good enough to go back to the bundle and to the Act of 2023 as amended. My learned friend's attention was drawn to Section 20, subsection 2, which was specific to the powers of the local authorities, Hamilton and St George's, to carry out construction works, which one could loosely call development works as well, and again the limitation on that, where such works are calculated to facilitate or conducive or incidental to the discharge of any function of the corporation. That actually takes one back to the vocabulary of Section 111 of the Local Government Act of 1972 and all the inhibitions and restraints on the exercise of powers of that character in the speeches in the Hazel case. But again, it cannot be suggested in our respect for submission. It's in a sense the same argument, just directed to a different formula. We say the provision of a luxury hotel to satisfy the demands of overseas travellers is not a municipal purpose, and equally it wouldn't be open to the corporation to develop such itself, but it would not be discharging its functions, the powers and duties that it otherwise enjoys. Its development of property development for profit may be, put using the loosest vocabulary, a good thing, but again it's abundantly clear that from Hazel and other cases that's not the function of a local authority. My Lord, Lord Sumption did raise a point in the context of this debate over a different section as to the limits on the power of local authorities to enter into profit-making enterprises. Now, I noted that in the court of first instance here, the decision before Mr. Justice Hellman, we did, and he recited very helpfully, the submissions of both parties as to the underlying principles in relation to the varies of local authorities. And if you'd be good enough to go to Volume 1 at tab B1, electronic reference 41 to 42, and go across to 42, where this was setting out the seven basic propositions that we relied upon. And at subparagraph 3, we submitted and continue to submit that if the corporation did have capacity to guarantee the liability of a third-party property developer, as it were, at all, because that's we'd taken issue with that at subparagraph 2. It did not have the capacity to do so where the third party was not incurring such liability to assist the corporation in the performance of its statutory functions. And I referred to the well-known decision of Mr. Justice Sargent in Attorney General and Fulham Corporation, where, if my recollection serves me right, the corporation had trespassed over the boundary between that which they were entitled to do and that which they were not entitled to do in establishing, I think, wash houses for profit. But anyhow, that is, if it's going to be of any assistance to the board when it retires to consider its advice to Her Majesty, that passage refers to what the corporation there previously did, which was permissible, and their extending of that, or their translation of that, into a profit-making enterprise, which it was held not to be intra vares, and that would provide an answer, in our respectful submission, to the notion of the car hire firm indulged in by the corporation in order to seek to make monies. My learned friend also suggests, and this is truly the last point here, that if there were any doubt, and this was in his written case at paragraph 15 at 934, if there were any doubt about the power of the corporation to give the guarantee under section 23(1)(f), that issue should be resolved in MIF's favour, given the clear intentions and understanding of the legislature. As he developed his submissions this morning, that appears to be a reflection of the argument as to what the legislature intended and understood by the amendments made in 2013, rather than to the words of 23(1)(f) read prior to those amendments. But my learned friend did, however, advance an argument in the next paragraph, suggesting that the Court of Appeal and Mr. Justice Hellman had in fact erred because they had failed to take account of the context in which the section appeared. But we respectfully submit that he was unfair insofar as he advanced in his written submission, insofar as he is continuing to advance the submission, because what Mr. Justice Hellman said and what the Court of Appeal endorsed was that the rival constructions advanced by my learned friend on the one hand and myself on the other as to what was meant by a municipal purpose of an extraordinary nature was equally persuasive, considered in isolation. And that was what was said. Orthodox principles of statutory construction require that one construes the language of 23(1)(f) in its statutory context, which is exactly what the courts below have done. One goes back to what Lord Staines's classic statement, in the law, context is everything. And ultimately what the courts below found was that the construction of the section asserted by the corporation was, in its plain linguistic meaning, but read, of course, in such context, tilted the argument in favour of the corporation. And I merely remind your Lord, my lady, in reflecting upon the rival arguments, to refer back to paragraphs 38 to 41 of the Court of Appeal's judgment, which you will find in the first bundle of authorities at the first bundle of the record, at pages 17 to 19, and indeed in the Court of the First Instance judgment at paragraph 41. And we say that if and insofar as my learned friend seeks to obtain any nourishment at all from what subsequently appeared to be the views of the legislature as to section 23(1)(f), in our respectful submission, one simply cannot use such extraneous and collateral evidence to trump the plain linguistic meaning of the section. As I say, it may be that at the end of the day, what my learned friend was doing there was to advance arguments directed towards the second and third of the routes that he sought to open up, which your lordships and my lady have said are routes that I need not explore. So subject to those are my submissions in relation to route number one, as I've described it. Unless I can be of any further assistance.
Thank you very much, Mr. Beloff. Mr. Myers, do you follow? Lord Panic.
The board will have noted that Mr. Beloff did not dispute my contention that the statutory amendments were designed to cure any problem as to validity. And he made no submissions in relation to my contention that the legislature specifically authorised the guarantee in this case, and it therefore follows from that necessarily that the legislature understood and intended that the legislation it had enacted should validate this guarantee.
He did make submissions on that point. He said it was irrelevant.
He said it's irrelevant, but he made no submissions in relation to what was the intention and understanding of the legislature. In relation to section 23, which my friend did address, my friend began by saying that the corporation relied upon the fact that Mr. Flint and others had advised that Section 23(1)(f) did not cover the guarantee in this case. It may just be helpful for a moment to look at Mr. Flint's advice. And the reason I do this is because in my submission it does not accord with the submission that Mr. Beloff makes as to the scope of Section 23(1)(f). Mr. Flint's advice is at volume 2 of the record, at tab 3, at page 284. And Mr. Flint specifically addresses the meaning of Section 23(1)(f) at page 287. It's paragraph 13 of Mr. Flint's advice with Mr. Clark. And it's the bottom of page 287, the last two lines, where Mr. Flint says that is consistent with Section 23(1)(f), which refers to municipal purposes, which suggests purposes related to the government or administration of the municipality. Yes, of course. We have not found any authority on the meaning of municipal purposes, but the note in Arnott, which is the Scottish case that my friend referred to, is consistent with the view that it refers to the powers and duties traditionally exercised by councils in works of lighting, cleansing and draining in towns. Statutory definition of those limited municipal purposes for which rates may be levied does not suggest the corporation has a general power to provide financial assistance to a commercial developer, even where the development is considered to be beneficial to the municipality and its residents. So that's the approach adopted in the advice given by Mr. Flint. And the reason I emphasise that is because that is, with great respect, simply inconsistent with the submission that Mr. Beloff makes and has to make, that Section 23(1)(f) is broad enough to cover the provision of a theatre, an opera house, or a sports stadium. And my Lord Sumption put to my friend Mr. Beloff, is the corporation permitted to set up a tourist office? And the board heard Mr. Beloff's response. He was understandably reluctant to commit the corporation on that point. And the reason he's reluctant to commit the corporation is that a narrow meaning of municipal, the meaning for which he contends, demands a negative response that the corporation would not have any such power. But in my submission, it would be very surprising indeed if Section 23(1)(f) were intended to deny the corporation such powers. Our case is that if, as Mr. Beloff accepts, the building of a theatre, an opera house, or we say a tourist office in Hamilton, is within the scope of Section 23(f), we respectfully ask, what distinguishes the building of a hotel if the corporation believes that its services, like the services of a sports stadium or a theatre, are of benefit to the people of Hamilton and indeed will raise funds that will benefit the people of Hamilton? My Lord Assumption suggested in argument that there may be a distinction between the substantive development and the giving a guarantee, to which our answer is that the guarantee is incidental to the substantial development, in that the corporation gave the guarantee in order to ensure that the development could proceed. There's no dispute about that. That's why the corporation gave the guarantee, to ensure that the substantial development could proceed. My friend Mr. Beloff referred to Lord Templeman's statement in Hazel. Could we go back, please, to Hazel, which was the authorities volume 2, tab 19. And the board will recall that I had relied on the statement at page 29, it's volume 2, tab 19, page 1502, page 29 of the law report, which sets out between D and E the general principle as to what may be regarded as incidental. And in my submission, the giving of the guarantee falls well within the concept of incidental or consequential, if I'm right in submitting that the substantial development could fall within section 23, 1F. My friend Mr. Beloff referred to page 31E, and I accept that the authorities also show that a power is not incidental merely because it is convenient or desirable or profitable. But that's not my case. My case is that the guarantee is truly incidental because the substantial development falls within the scope of section 23, 1F, and it's the guarantee which is incidental to that. My friend drew attention to the Scottish case of Arnott, Authorities Volume 1, tab 9. As the board has seen, the decision there focused upon the preamble, and I'm very conscious that my Lord the Deputy President asked to see the preamble, and we will supply it. But that was the context in the Arnott case which led to the Sheriff's conclusion. Mr. Beloff has not submitted that the text of the 1923 Act provides any similar clear indication. My friend then relied on the principle of e justem generis, to which our response is that the principle cannot assist in this case because section 23, 1F has the specific function of empowering the corporation to do something distinct from the other provisions of section 23.1, and it would frustrate that purpose of 23.1F then to confine section 23.1F by reference to what appears in the other sub-provisions. My friend emphasised it's not sufficient that the purposes are extraordinary, they must also be municipal. And of course he's correct. Our response is that the meaning of the protean concept of municipal, and it is a protean concept, must depend upon the context. And the context includes the rest of 23.1, and what we say is its evident purpose to allow the corporation to do that which is otherwise not permitted. We do not accept that our approach to municipal makes it otiose. It would confine the validity of actions taken within its scope to those within the bounds of Hamilton in the reasonable interests of the ratepayers. Two other points. My friend contended that if there is an ambiguity, section 23.1F should be given a narrow instruction because of the consequences for increased rates. But we're looking at section 23.1F as a provision which is said to confer powers on the corporation, or at the very least set out its powers. And in my submission, the relevant principles in that context are those stated by Lord Templeman in Hazel, and an approach which ensures that the corporation can act for extraordinary purposes as approved by the Minister. Finally, my friend relied on the 2018 Act and the amended Section 7 relating, as the board recalls, to directions given by the Minister to the corporation. We respectfully doubt that this throws any light on the proper interpretation of Section 23.1F. That the amendments refer to the best interests of Bermuda cannot assist on the meaning of municipal in Section 23.1F. Those are the points by way of reply. Anything else would be a repetition set in opening. Those are my submissions, unless there are other points on which I can seek to assist.
Thank you very much.
Said a short point.
Yes. Well, we're most grateful to Council for their assistance and to all those who've been involved in the preparation of the parties' cases. We shall now take time to consider what advice we shall tender to Her Majesty.